I need to put in one first.
Good morning, everyone. Today is Tuesday, August the 14th, 2018. It's 10 a.m. It is my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mrs. Bohannon, will you please call the roll?
Dennis Bridges.
Here.
Mark Cochran.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Bohannon. Before we proceed in the adoption of the agenda, on behalf of the board, I just want to formally recognize the death of our executive director, Mr. Robert Gribble's wife, and to let him know that we certainly have had him and his family in our thoughts and prayers.
Mr. President, I appreciate each one of you. Thank you.
We'll move on to the adoption of the agenda.
Motion to approve. Second.
I have a motion by Mr. Duffer, a second by Mr. McKinney to adopt the agenda. All in favor?
Aye.
On the minutes, we have the May 8th minutes for our approval. We'll take just a minute to review those if you haven't. Are there any noted corrections or changes to these minutes?
I'll make a motion that we approve the minutes as printed.
Second.
I have a motion by Mr. McKinney, a second by Mr. Bridges to approve the minutes from May 8th, 2018. All in favor?
Aye.
Our next item on the agenda is the legal report. Good morning, Ms. Gino.
Good morning. Our first four items on the legal report are related. The first one is complaint number 2018-026-221. That is an establishment. The second is 2018-02-6241, funeral director number 1. The third is 2018-02-6261, embalmer. And the fourth is 2018-02-6281, funeral director number 2, who is not the managing director. As you can see, there is some history with the establishment, but not with the funeral directors or embalmer. Complainant, funeral director / embalmer, alleged respondent establishment and respondent funeral director number 1 aided and abetted respondent funeral director number 2 to engage in unlicensed embalming. Respondents denied this allegation. An investigation was conducted. The results of the investigation did not support a finding of unlicensed activity. Respondent Funeral Director Number 2's wife is a licensed funeral director and embalmer. Over the years, she has performed trade embalming and other work for Respondent Establishment when Respondent Funeral Director Number 1 was not available. In 2014, for personal and health reasons, the wife requested her husband, Respondent Funeral Director Number 2, be made the point of contact if Respondent Establishment and/or Respondent Funeral Director Number 1 were in need of her services. She also requested all checks for her work be made out to her husband because he handles their banking and bill paying. By affidavit, the wife attested her husband would accompany her when her services were needed, and while he would assist her, he did not embalm bodies. The wife also attested her husband has assisted Respondent Funeral Director Number 1 with removals, dressing, casketing, and conducting funerals. Recommendation: Respondent Funeral Establishment, close. Respondent Funeral Director Number 1 / embalmer, close. Respondent Funeral Director Number 2, close.
Mr. President, I want to excuse myself, recuse it for the illegal report today.
All right, let the records show that Mr. Duffer has recused himself.
Motion to approve.
Second.
I have a motion by Mr. Bridges, a second by Mr. Cochran to approve the recommendation. All in favor?
Aye.
All right, next.
The next two items, items 5 and 6, are related. The first one, complaint number 2018-026-011, is an establishment. The second is complaint number 2018-02-6681, funeral director. Both have some disciplinary history. During an inspection, a board field representative discovered Respondent Funeral Director's license expired December 31st, 2017, but the requirements for reinstatement were not met until January 10th, 2018. During that time, Respondent Funeral Director remained an employee and manager of Respondent Establishment. 3 services were held during that time. Neither respondent responded to the complaint. Recommendation: Respondent Establishment, authorization for a formal hearing, authorization of a civil penalty in an amount of $250. Respondent Funeral Director, authorization for a formal hearing, authorization of a civil penalty in an amount of $250.
There's still been no response to this date.
To my knowledge, no.
Motion to approve.
Second.
I have a motion by Mr. McKinney, a second by Mr. Bridges. All in favor?
Aye.
The next two items on the report, items 7 and 8, are related. The first is complaint number 2018-029-791, establishment. The second is 2018-02-9841, funeral director. The establishment has some disciplinary history. The funeral director does not. During inspection, a board field representative discovered Respondent Funeral Director's license expired on January 31st, 2018, but the requirements for reinstatement were not met until April 26, 2018. During that time, Respondent Funeral Director remained manager of Respondent Establishment. Respondent Funeral Director also served as the funeral director for 5 services during that time. In response, Respondent Funeral Director indicated a payment was made to the board for the renewal fee on January 31st, 2018, but he was lacking his continuing education hours. The licensee, unsure of gender, claimed he received notification from the state that because he lacked his continuing education hours, his license would be placed on a 90-day grace period. He indicated he believed he could still act as a funeral director during this grace period. However, by letter dated February 8, 2018, the executive director for the board specifically advised Respondent Funeral Director's renewal fee was not received prior to the expiration date of the license, and that, quote, according to Tennessee Code Annotated Section 62-5-316, this license is now invalid, and you shall not practice the profession for which the license was issued until such time as the license has been renewed, reinstated, or a new license issued by the board, close quote. The letter also advised that in order to renew/reinstate the license, the board must receive payment of the penalty fee and the renewal fee within 90 days of the expiration of the license, and if the continuing education was not completed by the license expiration date, the renewal application was considered incomplete and subject to a late penalty fee. Respondent establishment indicated it was under the understanding respondent funeral director's license had been applied for within the time limit of expiration, that the license was not renewed due to a lack of continuing education hours, and that respondent funeral director had a 90-day grace period to fulfill the obligation without penalty. Recommendation: respondent establishment, letter of warning, respondent funeral director, authorization for a formal hearing, authorization of a civil penalty in an amount of $250.
Discussion.
Is this a full-time employee of an establishment? Do we know?
The respondent funeral director, I believe he was.
They're the manager of the establishment.
Okay, okay. Make a motion to approve.
Second. I have a motion by Mr. McKinney, a second by Mr. Shackelford. All in favor?
Aye.
Next.
The next item is complaint number 2018031041, unlicensed establishment. Anonymous complaint filed alleging respondent does not have a place to have funerals or anywhere where flowers may be sent, and the decedent cannot be viewed unless you go to the family hour. In support, complainant provided newspaper clippings of 7 obituaries. The obituaries indicated services for the respective deceased persons would be held at specific churches, and the flowers could be sent to the same. The obituaries also provided professional arrangements were entrusted to respondent at a licensed establishment in another city in Tennessee. In response, respondent indicated it had several hundreds of families and had never had an issue with viewing of bodies or florists being able to deliver flowers. Recommendation: close.
Motion to approve.
Second.
I have a motion by Mr. Bridges, a second by Mr. Cochran. All in favor?
Aye.
The next 2 items on the report are items 10 and 11. They are related. Complaint number 2018032991, an establishment, and complaint number 2018033011, funeral director. During an inspection, a board field representative discovered respondent funeral director's license expired from April 1st, 2018 through April 7th, 2018. During that time, respondent funeral director remained manager of respondent establishment. There were also 7 statements of funeral goods and services contracts written by respondent establishment during that time. In response, respondents did not deny the allegations and apologized for unknowingly allowing the license to lapse. I would also like to mention that both the establishment, or neither the establishment nor the funeral director, have a disciplinary history. Our recommendation is respondent establishment, letter of warning; respondent funeral director, letter of warning.
Motion to approve.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
The next item is complaint number 2018035121, establishment with some disciplinary history. Complainant alleges the burial vault company mistakenly delivered his mother's concrete vault to respondent and that respondent used the vault for another deceased. In response, respondent indicates it had no knowledge the burial vault company had delivered the vault to the wrong cemetery. It also indicates it had no knowledge the vault did not belong to the deceased for whom it was providing services. Respondent indicates it was told by the family that the church would be taking care of all arrangements associated with that deceased's burial. When respondent staff arrived at the cemetery, there was a full setup, including the vault, and the cemetery sexton said, quote, "The grave was for the deceased and was the only grave that was dug for that day," close quote. It was not until later that respondent discovered the vault had been mistakenly delivered and that it did not belong to the deceased for whom it provided services. Recommendation, close.
I have a motion by Mr. Bridges. Is there a second?
Second.
Second by Mr. McKinney. All in favor?
Aye.
Opposed?
The next four items are related. We have, 5 items are related. First off is complaint 2018030721, establishment. Complaint number 2018030791, funeral director number 1. Complaint number 2018030831, embalmer number 1. Complaint number 2018030871, funeral director number 2, who is not the managing director. And complaint number 2018030901, embalmer number 2. The establishment has some disciplinary history, but the funeral directors and embalmers do not. In her complaint, complainant, consumer, alleged the following. 1. Respondent funeral director number 1 failed to provide her with a price list or statement of funeral goods and services. 2. Respondent funeral director number 1 made false statements, including that there was a 10-day waiting period for cremation and that 3 doctors refused to sign the death certificate. 3. The deceased did not receive a military funeral. 4. Respondents forged her name on a statement of funeral goods and services and on an insurance claim for pre-need funds. 5. Respondents failed to refund her the $640 excess for opening/closing of the crypt, which was not performed. 6. It took 33 days for respondent to cremate the deceased. She also alleged that after the above acts and omissions, she met with a director for respondent establishment, but nothing was accomplished. She claimed he stated that she needed to move on with her life and that he would not pursue the forgery matter. In response to these allegations, respondents indicated as follows. 1. Respondent funeral director number 1 generally denied the allegations against him, indicating A. He had no reason to believe complainant was not offered a price list, but he could see where the price list would not have been of concern to complainant since she presented with a pre-need contract and the cremation cost was guaranteed. B. Complainant did not receive a statement of funeral goods and services at the arrangement conference because the insurance company was having system issues and could not provide the establishment with a current death benefit before the family arrived. C. He was not present when the purported forged documents were signed. He, however, was told complainant signed the documents. D. A military funeral was not provided due to complainant's delay in providing the proper documents. Complainant did not provide the proper documents until the day before the memorial service. He called the Army to make arrangements, but they were already full for the day of the service. E. He did not tell complainant there was a 10-day waiting period for cremation. Rather, he told her the establishment could not cremate without a certified death death certificate, which could take 10 to 14 business days to receive. F. There were issues getting the death certificate signed because the hospital initially provided a traveling hospitalist to sign the certificate. The hospitalist's secretary referred the establishment to the surgeon, who was out of the office at the time. When the surgeon returned, he advised he would not sign the certificate. 2. Respondent establishment indicated it cannot verify what took place at the arrangement meeting. However, funeral director number 1 was trained to comply with the funeral rule and was aware of respondent establishment's policy to provide a price list and contract copy to customers. B. Respondent funeral director number 1 is no longer employed with it. C. Respondent funeral director number 2 denied forging complainant's signature on any document and stated she witnessed complainant executing all the documents herself. D. Complainant was refunded $1,635. E. Complainant mischaracterized the conversation with the director. He did not tell complainant to move on with her life and did not state that he would not pursue the forgery matter. Due to the conflicting narratives, an investigation into this matter was conducted. The investigation revealed: 1. Respondent funeral director number 2 met with complainant on March 6, 2018, after services were provided. She was told to have complainant sign the statement of funeral goods and services and the insurance claim during that meeting. However, she failed to do this before complainant left. In effort to prevent complainant from having to return to the establishment, respondent funeral director number 2 stated she believed it would be acceptable for her to sign the documents for complainant, which she ultimately did. 2. Several family members present during the arrangement conference corroborated complainant's allegation that respondent funeral director number 1 told her there was a required 10-day waiting period before a person could be cremated. The family members also corroborated the allegation that respondents did not provide complainant a price list or statement of funeral goods and services at the arrangement conference. 3. The deceased died on January 14, 2018. However, respondent establishment did not receive the signed permit from the state and consent from medical examiner to cremate until February 7, 2018. Complainant met with respondent funeral director number 1 on February 14, 2018 to sign the cremation viewing disclosure acknowledgement and release of liability form. The deceased was cremated on February 19, 2018. The cremated remains were delivered to respondent establishment on February 23, 2018. 4. Respondent establishment refunded complainant the total amount paid for the pre-arranged cremation. Manager for respondent establishment advised it would also refund the interest received on the pre-need policy. Recommendation. Respondent establishment, letter of warning. Respondent funeral director number 1 / embalmer number 1, letter of warning addressing compliance with funeral rule. Respondent funeral director number 2 / embalmer number 2, authorization for a formal hearing, authorization of a civil penalty in an amount of $250.
Mrs. Gino, what was the reasoning behind not pursuing a penalty for funeral director number 1 and embalmer number 1 as well?
And the establishment.
With funeral director number 1 and embalmer number 1, he did not have a disciplinary history, and his issue here was the potential failure to provide the statement of funeral goods and services and a price list, which when we received his response, he didn't necessarily, he generally denied the allegations, but couldn't entirely, I think, recall whether or not the price list was provided. And like I said, stated that he could see where that wouldn't have been of concern due to the cremation cost being guaranteed, I believe. So it just didn't seem like, given his lack of a disciplinary history and the violation here just being failure to comply with the funeral rule, that a letter of warning was more appropriate. But certainly y'all are welcome to change that if you believe it needs to be changed.
Well, just from my understanding going through this, if number one had done his job, number two wouldn't have been put in the circumstances he was put in. Am I correct with that? If he had gotten the family member to sign the itemization to start with, he wouldn't have had to, number two wouldn't have had to forge a signature. Am I hearing that wrong?
They didn't have to, but they did.
Yeah,
They were
well.
put in a position where that they did, so. The establishment has sort of a history of FTC and cremation violations also.
So the complainant already had a pre-need contract that was signed. I mean, she did have that.
Yes. Yeah.
Okay.
We'll also note that the contract was guaranteed, and so that kind of went into the recommendations as well.
Right. Sorry, I'm thinking.
Yeah, was there a reason the establishment that you didn't recommend anything for them?
Our investigation didn't reveal that the establishment had known or had any way indicated to funeral director number 2 to sign this woman's, or to sign the consumer's name on a statement of funeral goods and the insurance claim. So because the establishment, I believe, was not aware that had happened until after the complaint was filed and the complainant complained about it, I recommended a letter of warning for them.
The establishment did refund all their money, so.
Okay.
They also refunded the amount received as interest on the insurance policy as well. So I don't believe the establishment actually got anything at all from providing these services.
Okay, thank you. I would feel better if the first one was penalized along with the second one. As my mom stated, of course, the second one, didn't have to forge, but they wouldn't been put in that position had the first one done what they were supposed to do.
I would like to point out as well that the second funeral director did indicate that she was told to get the complainant to sign the documents when the complainant came in to meet at the establishment. She just failed to do so.
Kenny, do you want to put that in form of a motion?
I will. A civil penalty for the first funeral director embalmer $250, and then I'll go along with the second one of 250.
I have a motion by Mr. McKinney to do a civil penalty on funeral director embalmer number 1 of $250, and to do recommendation of $250 for funeral director and embalmer number 2.
Second.
I have a motion by Mr. McKinney, a second by Mr. Shackelford.
I have one real quick question, if that's okay.
Absolutely.
The statement of funeral goods and services and the general price list, again, sorry, as the outsider, are those two separate documents that are signed? I mean, are both of those documents signed? I guess is my ultimate question. Is the price list signed as well as the?
Not typically.
Okay, okay. That's all I need to know. Thanks.
All right. Any further questions? We have a motion and a second. All in favor?
Aye.
Opposed?
I just want to clarify, because I wasn't sure whether the motion just addressed respondent funeral director number 1 and funeral director number 2, or it was also accepting the recommendation for the respondent establishment as well, which was again a letter of warning.
Yes.
Okay.
Yes, that was my intent. I'm sorry for not making that clear.
Was there anyone that voted that felt they voted otherwise? All right, thank you. That conclude the legal report.
Yes, sir, that
All
does.
right. Thank you. Next on the agenda is the director's report. Mr. Gribble?
President and board members, the first is a legislative update for this meeting. The board office has not been contacted by the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association regarding any possible legislation they intend to pursue during the next legislative session. However, the office has been contacted recently by an individual who owns 2 funeral establishments in Middle Tennessee concerning his interest in legislation regarding alkaline hydrolysis. This person is to follow up with detailed plans regarding possible legislation that he intends to pursue in the upcoming session. Benefit of the board members, this was something that the board looked at back at the time. Dennis Hamilton was either the vice president or president of the board, so that kind of gives you a timeline. It's been a few years. There was some legislation introduced by a representative from Hamilton County, because there were two individuals who were not funeral directors and embalmers, but they were thinking about had some interest in pursuing a business there, and so the legislation was introduced probably, I don't know, 6 years ago, something like that. It did not pass at the time. Just for your information, the point of contention is to whether you amend the cremation statutes and allow it to be done fairly without a lot of adjustment to the statutes, or whether you do new statutes for alkaline hydrolysis and address that in a different way. So that, according to what the gentleman who has some interest in doing this, his preference is to amend the cremation statutes, basically change the definition of cremation, is what he's told me. Now, he and I have had some conversations, and he's supposed to follow up and then have a meeting with legal and maybe our legislative team, someone from that team, to see more what his concrete plans are. But he hasn't done that of yet, but I expect that he may do it in a while. So just wanted to make you aware of that that's something probably.
Just out of curiosity, alkaline hydrolysis, is that a way to cremate a body? What is that exactly?
It's a way of disposition for a body. Let me look up the.
I mean, yeah, you don't.
Let me look up the definition for it, so I give you not what I would do in layman's terms, but
You get the same result. It's just
That's what I was
done in a
curious.
different
process.
process.
Okay.
Mhm.
Yeah.
Do you know what other states have done concerning that?
I think there are about 14 states that have passed legislation. Some have done it one way and some another way. If we get to that point and we bring it back to you and talk to you, we'll do some research and have a better, more information available for you at.
Guess I was wondering if the process had taken hold more now than it had 5-6 years ago. What is it anymore?
There's a gentleman in Florida, I think, that does probably quite a few cases with alkaline hydrolysis. When I Google this is what comes up. It's Mr. Cochran. It's a process for the I'll read what it says. A process for the disposal of human remains, which produces less carbon dioxide and pollutants than cremation. The process has been marketed as an alternative to the traditional options of burial or cremation. And it's, I know there was, I think Illinois was one of the first states that it was done in, and they did it for a few months, and then they said the laws weren't in place, and so they stopped it, and I'm not sure if that's been restarted or not. But I just did some brief checking. I think there are 14 states or something to that effect that currently have laws that. I would suggest that if he wants to pursue this, it not only meets with us, but he meets with both the funeral director associations and talk to the board and kind of get ideals from everybody before it gets up to the legislature for consideration up there. Next is the licensee report. This is the report of licenses administratively approved by the executive director pursuant to board authority for the period of June 20, 2018 through August 13, 2018. And you have a list of those, several of those being the change of ownership as far as the establishment, and some individual licenses as well. Closed establishment report. One establishment has reported closing since the last board meeting, and that was the Life Celebration Center of Franklin, which was located 1881 George Patton Drive, Suite 102 in Franklin, Tennessee. Action report. This is a report of consent orders that have been administratively accepted and approved by the executive director pursuant to board authority and as reported on the June 2018 regulatory board's disciplinary action report. Have two there. As far as the complaints, as of yesterday, we had 35 that were against either funeral director and/or embalmers, and 28 against establishments, for a total of 63 complaints. I'll be glad to answer any questions that any board member might have.
Any questions for Mr. Gribble?
Motion to accept director's report.
Second.
I have a motion by Mr. McKinney and a second by Mr. Duffer. All in favor?
Aye.
Next, we have the approval of license applications.
Board members, there's one individual application before you today. It's the application of Scott Thomas Gullett of Kevy, Kentucky. I'm not sure how that town's pronounced. His application is for embalmer by reciprocity from the state of Kentucky. The applicant is seeking licensure as an embalmer, and he currently holds a funeral director license number 20154 that was issued, and I could have administratively approved that on July 15, 2018. And based on the embalmer application, the board may, among other pertinent statutes and rules, specifically examine the applicability of Tennessee Code Annotated 62-5-311B3 in making the determination as to whether the applicant meets the requirements for licensure. In other words, this gentleman does not have the associate's degree, so his application is based on him having five years prior licensure and working in the state of Kentucky. And the pertinent part of that says may meet such qualifications provided that the non-resident applicant has been licensed by another state or provincial authority in good standing for 5 years and has been employed as a funeral director or embalmer, or both for such time. Mr. Gullett was invited to today's meeting and corresponded and communicated with Ms. Bohannon and said that he was not able to be here today because of a work conflict. But his application is on your iPad. Board members, actually all the documentation's in order. The only thing that I would like to point you to is your iPad, where there are two affidavits concerning his employment. And let me see if I can. It's near the end. Has an affidavit that's signed by Craig Singleton, who is at Singleton Embalming Service in London, Kentucky. And he says that Mr. Gullett has worked as a full-time licensed Kentucky funeral director and embalmer since October of 2015. So that would, and of course you'll see from his certification from Kentucky, he's been licensed more than 5 years. Then following that is an affidavit that Mr. Gullett makes himself regarding a business that is no longer, my understanding is no longer exists, Maple Grove Funeral Home and Cremation Services, and he said that he was employed there from June the 1st of 2012 through June 30th of 2015. And the next statement says he declares his employment was full-time basis, working 24 hours per week. So that's, well, obviously I couldn't administratively approve this because he didn't have the education, but that's the only thing that I guess I want to draw your attention to, is for you to make a determination, or at least when you make a decision that it says it's full-time, but it's 24 hours per week.
Mr. Gribble, am I reading this correctly, that he was the owner, funeral director of the Maple Grove Funeral Home?
That's the way that I read it. He was the owner, the funeral director, and embalmer.
He only worked 24 hours a week.
That's his affidavit, yes, sir.
We confirmed that business did exist, though.
Not independent from his affidavit, I did not.
Okay.
I mean, I have no reason to believe that it didn't.
Sure. Yeah.
But as far as to be able to tell you that I know he existed, no, I can't tell you that either.
Okay.
This is only application for embalmer's license?
Yes, his funeral director's license is already approved.
Okay.
And Mr. Cochran, if you look at the next, and I had not turned on over there, there is an establishment inspection report from the Kentucky Board of Funeral Directors and Embalmers.
Okay.
So for that business in March of, where they did an inspection in March of 2013, so it, I guess that would be independent verification that I'd looked at that but forgotten about it,
Okay. Got it.
that the business did exist.
Would it be out of order to table this till next meeting and see if he can appear?
I think there are a lot of unanswered questions, and he should appear before the board.
All right, with those words indicated, someone want to make a motion?
I'll offer motion that here before the board, that this item be tabled until his appearance.
All right, we have a motion to table this particular action by Mr. Davis. Is there a second?
Second.
Have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? Any other business?
No, sir, that's the only individual in there. There are no establishments to appear before you today. And
All right. Under new business,
Good morning.
good morning.
So next we have an update regarding the rulemaking hearing that's scheduled for October 9th. A rulemaking notice went out via e-notify on August 1st. That was a Wednesday about this rulemaking hearing for everyone that is on that list. The rulemaking hearing is going to be on October 9th, 2018 at 10 a.m. and it's going to be held here at this building, 500 James Robertson Parkway, here in the Davy Crockett Tower, room 1B. These rules do a number of things, and I'm just going to go through the things that were in the notice for those that may be watching the board meeting. These rules clarify the examination and grading procedures, adjust the fees for a number of licensees, require a submission fee for specialty forms to be reviewed, establish parameters on re-registering for apprenticeships, establish 90-day time limits for completing various applications for registration and or license, specify indicators regarding fixed places of business devoted to the care and preparation of dead human bodies, specify new requirements related to the care and preparation of non-human remains, clarify the new in-person and or virtual continuing education requirement, and add the option of obtaining continuing education credit by attending a regularly scheduled board meeting. A copy of these rules have been posted to the Secretary of State's website, so anyone interested can go on the Secretary of State's website and navigate appropriately to get a copy of those rules. Pursuant to the Tennessee Open Meetings Act, the hearing is open to the public, and any individual may attend in person. If anyone has comments about these rules, they can email those to me in advance of the board meeting. I'm Sherelle Hooper, Assistant General Counsel for the record. I can be reached at 615-741-3072 or be reached electronically at sherelle.hooper@tn.gov. Individuals also have the option of appearing at the rulemaking hearing to make any comments on the record. So that is the full update, the information that was contained in the e-notification for the record for those watching today's board meeting. Thank you.
Thank you, Mrs. Hooper.
Now, the next item, I'm going to discuss the Fresh Start Act with you all, and Ms. Bohannon has a handout for you all so that you can follow along.
You're good.
So what you have before you is a copy of the act itself and an internal memo regarding the act that kind of explains how it will actually work in practicality. The Fresh Start Act was passed by the General Assembly as 2018 Public Chapter 0793. It's going to be codified at Title 62, Chapter 75, Part 1, and it applies to all registrations, licenses, permits, and certificates issued by the Regulatory Boards Division, as well as any other occupational licensing program not exempted, including some attached to the Department of Health. It requires all licensing authorities that are not excluded prior to denying an application for a license, certificate, or registration on the basis of a criminal conviction to first make a determination that the criminal conviction directly relates to the applicable occupation, profession, business, or trade, even if the authorizing statute states that the board, commission, or assistant commissioner has the authority to deny, suspend, revoke, or refuse to issue a license. So, in short, essentially, there's going to need to be a prior determination prior to taking any disciplinary action or denying a license based on a criminal conviction, that it directly relates to this particular profession by this board. The individual must be notified before the action is taken by certified mail, fax, or email. And so that's written notification, and there's certain information that must be in that written notification. And number one, they need to know that the denial action is going to be taken due to a conviction. 2, they need to know the earliest date that they can reapply. And 3, there needs to be a justification that shows that the board considered a number of factors, and I'll go through these. These are the nature and seriousness of the crime for which the individual is convicted, the length of time since the commission of the crime, the relationship between the nature of the crime and the purposes of regulating the occupation, profession, business, or trade for which the license, certificate, or registration is sought. Number 4, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the occupation, profession, business, or trade. Number 5, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the occupation, profession, business, or trade. And finally, 6, any applicable federal laws regarding an individual's participation in the occupation, profession, business, or trade. Once an applicant or license holder receives this written notice, the new law gives them the option of filing a petition within 30 business days in the Davidson County Chancery Court to have the matter heard, and the licensing authority has the burden to show by a preponderance of the evidence that the conviction is directly related to the applicable occupation. I do want to kind of walk you all through the steps in looking at an issue involving a criminal conviction. Essentially, first, we're going to have to make an assessment of whether or not there's the authority to deny. If there is the authority to deny, a determination will need to be made as to whether you all, the board, wishes to deny such an application, even though you have the authority to do so. And then if you wish to deny, whether or not the conviction directly relates to the fitness of the person to hold the particular license. And finally, all the questions that I went through and the factors, those have to be considered. Once all those are considered, a determination is made, and then that written notice goes to the applicant or license holder, at which time they have the option, as I mentioned just a moment ago, to file a petition in Davidson County Chancery Court and have the matter heard. Procedurally, the way this would operate if an application came to you all and the board was looking at taking a particular action, we would need to make sure a vote was held on the issue of whether or not it directly relates to the profession. And you all would need to consider these factors, the ones that I went through a few moments ago on the record. Finally, you all would need to have a motion to adopt a Fresh Start Act justification statement. And that's something, obviously, that I would prepare on your behalf, but that would have to be adopted on the record by motion. I do want to point out, as far as the particular crimes, there is a rebuttable presumption in favor of the agency that the conviction relates to the fitness of a person to hold a license if it falls into one of 3 categories. Number 1, Class A, B, and C felonies, except those for drug crimes under Title 39, Chapter 17, Part 4. Number 2, any felony conviction for which the offender is required to register under the Tennessee Animal Abuser Registration Act, compiled in Title 40, Chapter 39, Part 1. Or number 3, any felony conviction for which the offender is required to register under the Tennessee Sexual Offender and Violent Sexual Offender Registration Verification and Tracking Act of 2004. And this is compiled in Title 40, Chapter 39, Part 2, or Title 40, Chapter 39, Part 3. Even in these cases, if the crime is in one of those 3 categories, you all would still need to make a determination and provide the required notice. But in essence, there's a burden shifting where those crimes are considered by law to relate to the fitness, and then the particular licensee or applicant has a burden to show that somehow it doesn't. So, are there any questions about the Fresh Start Act or how it might operate with the board?
I have a whole lot, but I guess we'll have to see how all this plays out. But I'm assuming on the applications that they'll still the applicants will still have to answer yes or no if they've been convicted of a felony or.
Yes, that's correct. The application process won't change. Essentially, this is just a new step and a new process to make sure there's some relationship between the actual conviction itself and the profession that the person is seeking to enter. Or maybe the person already holds a license and there's a need to potentially take disciplinary action. So this is an additional measure to go through certain factors and ensure that there's a relationship there between the criminal act and licensure. Well, if there's nothing further, that completes my review of the Fresh Start Act. Thank you.
All right. Is there any other business that needs to come before this body? If not, I'll entertain a motion for adjournment.
So move.
Second.